Hello and welcome to Skyline's another episode, ladies and gentlemen. I'm Dhruti Athri. Now tonight we are going to talk about 13 stories that may look completely unrelated at first. Different stories, different countries, different systems. But there is one thing that is connecting all of them. The rules are changing, and for the Indian diaspora, well, these changes are not happening somewhere far, far away. They can affect your job, your visa, your green card, your family, your money, your safety. So tonight, don't just watch the headlines. Let's connect the dots because this is Skyline with Dhruti Athri. If you are an H-1B, L-1, B-1, B-2 visa holders who are planning a trip back home to India to get your infant or minor child stamped, stop right now. Well, the US Embassy has just issued a critical warning that could ground your entire family's return flight. Well, for years, one of the few conveniences Indian tech workers and NRI parents had when traveling back home to India for US visa stamping was the interview waiver for the young children. If your child was under 14, you could traditionally drop off their passport and DS-160 at a VAC Dropbox center. You didn't need to drag an infant or a young child through the lines at the US Embassy in New Delhi, Mumbai, Chennai, or maybe Hyderabad, Kolkata. That era is officially over now. That's right, in an official Visa Friday clarification released by the US Embassy in India, Consular authorities confirmed a strict policy. Every single minor visa applicant, regardless of any age, must physically appear in person at the consular interview window. Whether your child is 17 years of age or maybe 2 weeks old, a newborn, well, they must be physically present at the embassy or consulate. Well, parents are no longer allowed to attend the consular appointment alone on behalf of their child. That's right, according to the US consular officers, this mandate, it is tied directly to updated biometric, identity verification and national security vetting standards. Well, the officers are legally required to visually confirm the physical presence and identity of every single individual listed on the US visa application before granting the approval. And this creates a massive logistical headache for cross-border tech families. Many H-1B and L-1 professionals living in the US return to India specifically during maternity leave or maybe major family events. Under previous expectations, parents scheduled Dropbox appointment, assuming that they could drop off the baby's document and collect the passport stamped with an H-4 or maybe B-1 or B-2 visa. If you show up to your interview window in India today without your child physically in arms or beside you, then officers will flatly reject the visa application process further, forcing you to reschedule. Which, by the way, in India's current visa ecosystem, it can mean months of catastrophic delay further. And yes, while one family is dealing with the new visa interview rules, another group of Indians in America are facing a completely different immigration battle. If you're currently in the US on an F1 student visa, J1 visitor visa, or working through STEM OPT, a high-stakes legal showdown in federal court could decide whether your legal status in America could get shot or not. Well, for decades, foreign students, academic researchers, international journalists entering the United States operated under a foundational rule, that is known as duration of status, DS rule basically. Under DS, as long as you maintained valid enrollment at a university, stayed in good standing, and abided by service requirement further, your visa status remained valid for the entire length of your program. That multi-decade framework, it was shattered when the United States Department of Homeland Security published a sweeping final rule. Starting September 15th, DHS is replacing duration of status with rigid, fixed periods expiration date. Under this new system, F1 and J1 student visas are capped at a maximum period of 4 years. Now, for foreign media and journalists on I visas, the limit drops to 240 days, and for Chinese journalists, down to 90 days. If your PhD, medical residency, or master's program, it takes longer than 4 years, well, your status simply expires until and unless you navigate a complex extension process. Now, a massive coalition of higher education leaders, labor union, and rights organization, including NAFSA, the President's Alliance on Higher Education and Immigration, the American Federation of Teachers, and the UAW, has filed a lawsuit in the US District Court in Massachusetts. They have formally requested an immediate injunction to freeze and block this rule before it takes effect on September 15th. Well, the lawsuit charges DHS with violating the Administrative Procedure Act. It points out that DHS rushed the regulatory system. They ignored critical public feedback and failed to account for a catastrophic financial and administrative damage, inflicted on the American higher education. For South Asian tech students and graduates, the concern that is specifically serious. Why? Because a standard undergraduate degree takes 4 years, while a master's, followed by 36 months of OPT and STEM OPT, it can push total continuous stay to 5 or 6 years. Well, under the fixed term admission, international students could be forced to file formal extension of stay application directly with the USCIS. While the federal court considers the injunction, international students and graduates, they must protect their legal standing immediately by auditing their service timeline, preparing extension documents early, and monitoring the court docket very, very carefully. If you thought the Indian-American political lobby in Washington was an unstoppable force for the NRI policy interest, think again. The famous Samosa Caucus in the US Congress is fracturing, and the reason comes down to high-stakes political money, overseas lobbying ties, and intense progressive backlash. For years, the Indian tech executives, cross-border corporate leaders, and diaspora communities looked to this Samosa Caucus, the informal group of Indian-American lawmakers in the US House of Representatives, as their primary bridge to Capitol Hill. Well, from pushing for green card backlog relief and H-1B visa protection to strengthening the US ties with India, this group represented basically a pillar of South Asian political power in Washington. However, political realignment, it has kind of triggered a major shrinkage in their numbers and unified influence. Recent Democratic primary battles saw that prominent members, they lose their seats or maybe fall in higher bids. Congressman Mr. Raja Krishnamurthy of Illinois, he failed to secure his party's nomination during a high-stakes Senate primary run. And yes, Michigan's representative Mr. Sri Thanedar, he lost his seat after intense primary challenges here. You know what caused this political collapse? Well, an explosive political analyst in the Quint reveals that the external funding stream ties to foreign political movement and foreign policy lobbying. Groups like AIPAC have fractured the coalition from within. Campaign finance disclosures have also become a major point of political scrutiny now. In fact, in Michigan, Representative Mr. Sri Thanedar, he faced heavy criticism after campaign finance filing that revealed that nearly 2/3 of the individual funds raised in the single quarter originated from donors that were connected to AIPAC. Simultaneously, Mr. Sri Thanedar, he established a specialized Hindu, Buddhist, Sikh, and Jain caucus that explicitly excluded Muslim and Christian South Asians. In the meantime, in Illinois, Mr. Raja Krishnamurthy, he faced mounting scrutiny from the progressive wing of his party over donations that were accepted from high-profile MAGA-aligned tech investors and venture capitalists, along with his core alignment with Hindu nationalist organization. Well, the shrinking of Samosa Caucus, that creates a direct power vacuum for the 5 million strong Indian-American diaspora. Well, critical policy priorities for tech NRIs, including the green card backlog, H-4EAD work authorization, and country cap quotas. That requires a focused coalition here. Well, the lesson for diaspora's political power, it is clear. relying heavily on political money, identity battle, or foreign policy alliances that can create massive political vulnerability. And yes, while political influence is being questioned in Washington, another investigation is putting the immigration record of Indian tech workers under the microscope. If you or your employer ever submitted multiple H-1B registrations in the past lottery cycle, well, sadly, but a massive legal crackdown triggered out of Texas. It is now putting your visa status, your green card future in immediate risk. Well, a sweeping law enforcement crackdown is currently unfolding across North Texas. States and federal authorities have issued formal civil investigative demands and launched sweeping fraud probes into nearly 30 IT staffing firms and consulting companies. Names like Blooming Clouds, Without Solution, and Fame PBX are under direct state and federal investigation now. Core allegation? Well, these entities set up ghost offices, frictional corporate addresses registered to empty, unfinished building or single family homes to run massive, systematic, multi-filling scheme. Through those ghost setup, IT staffing brokers submitted coordinated, duplicate lottery registration for single foreign tech worker to artificially tilt the H-1B cap lottery in their favor. But what was once treated as a regulatory slap on the wrist, it has now escalated into criminal fraud probes, sweeping state freezes, and retroactive USCIS inspections targeting previous cap season. The reason this matters to Indian tech professionals is a landmark precedent ruling by the USCIS Administrative Appeal Office. Matter of Techspert. Well, in the past, when an employer or IT staffing firm received a notice of intent to deny or notice of intent to revoke due to suspicious multi-filing, they would simply withdraw the petition here. In the meantime, candidates assumed that withdrawing the petition made the entire problem all vanished. Now, under Matter of Techsperts, USCIS ruled that withdrawing an H-1B petition does not erase the agency filing here. The federal government explicitly reserves the legal right to record formal finding of fraud or willful misrepresentation on the record, even if the petition is withdrawn. Well, the agency is also actively auditing historical lottery registration now. Well, if system shows that your name was registered by multiple consulting firms sharing the same IP address, identical HR names maybe, or identical job letters, the agency treats it as an evidence of coordinated fraud. If you previously used consulting firms, staffing agencies, and mid-size vendors during your H-1B lottery process, the immediate action it is to audit your registration history, review your past employer ties, and seek qualified legal advice in any previous vendor appear in an investigation. But yes, there is another corporate strategy affecting Indian tech workers. And this one, it begins not with offices, but inside the office itself. Well, if your United States employer just enforced a strict 5-day return to office mandate, and that too with zero flexibility, do not assume it's just about corporate culture. It is a calculated mechanism designed to trim the US headcount while quietly moving your engineering seat overseas. That's right, across Silicon Valley, Wall Street, and major tech corridor, Fortune 500 corporations are ruling out the mandatory return to work policy. Well, companies like Amazon, Dell, Home Depot have made it clear: comply with physical office batch in or hand in your voluntary resignation. To the average tech worker, this looks like a battle over office culture or maybe a commercial real estate investment. But behind the corporate boardrooms, RTO mandates, they are executing a sophisticated double play. First of all, they operate as silent layoff by enforcing strict office presence without offering the reverence packages. Companies trigger voluntary turnover among remote tech staffing who cannot relocate or afford local living cost. Second, as domestic US seats are vacated through these those exact positions are not being rehired in San Francisco, Seattle, or New York. Instead, they are being systematically migrated to offshore global capability centers here in India. It's a big shift, by the way. The shift happening today is fundamentally different from the traditional third-party outsourcing wave, by the way. Well, that is for, if you remember, that happened in 2000s. US tech giants are no longer handing off the low-end support tickets to the vendors, BPOs. They are now building wholly owner, high-tech global capability centers directly in tech hubs like Bangalore, like Hyderabad, Pune. According to industry metrics, India currently hosts over 1,800 GCCs, representing more than half of their entire world's total, employing more than 2 million tech professionals and generating over $64 billion in revenue. Well, US headquartered companies account for a massive 70% of that total demand here. You know, what makes this transition a catastrophic one for the domestic US tech worker is the cost differentiation here. Well, a senior cloud, AI, or platform engineer in San Francisco or London carries a fully loaded cost of $200,000 to $350,000 annually. Well, an equivalent senior tech lead at the GCC in Pune or Bengaluru costs between 20% to 30% of that amount. Well, by pairing RTO attribution in the US with aggressive GCCs hiring in India, corporations achieve 60 to 70% operating cost reduction per engineering pod. And you know that offshore shift, it is not slowing down. In fact, the next story shows just how deeply the GCC model is changing the big techs. Well, if you are an H-1B holder or a tech worker in the US, Canada, or Europe, pay close attention here. Ladies and gentlemen, big tech, it is not just cutting headcounts now. It is permanently reallocating high-paying engineering roles directly to global capability centers in India. States like Bengaluru, states like Hyderabad, Pune. Well, for years, tech layoffs were viewed as maybe a cyclic downsizing here. But 2026 has proven that what we are witnessing is a permanent structural migration of corporate workforce seat. Well, industry tracking reported by the Times of India reveals tech industry workforce cut crossing over 92,000 roles in a single wave. And that's a lot. However, while onshore teams in San Jose, Seattle, or Austin face headcounts freeze here, well, corporate budgets are aggressively shifting towards India GCC hub. Oracle, Amazon, Meta, they are leading this global realignment, by the way. Reports covered by NDTV Profit and CRN Asia highlights that big tech companies are rebalancing the multi-billion-dollar AI capital expenditure by streamlining the Western operation while simultaneously expanding strategic capability centers in India. Well, data from People Matters, it indicates that India-based GCCs are expanding from support tasks into high-value AI modeling, in fact, core enterprise architecture and strategic engineering mandate. You know, for Western non-resident Indians on H-1B visa or awaiting perm labor certification, this workforce reallocation, it carries severe consequences. Now, when US corporate roles are eliminated or moved offshores, perm green card applications freeze automatically. Well, the 60-day H-1B grace period, that becomes harder to navigate when the Western tech firms are not backfiling roles locally, but instead they are routing directly to their captive hubs in India. According to the industry reports, ladies and gentlemen, India now hosts over 2,100 global capability centers, employing over 2.36 million tech professionals here. In fact, NASSCOM projects over 450,000 new GCC seats being aboard in 2026 alone. And you know the best part? These are no longer back office support hubs. They hold global product ownership and strategic decision-making authority. But the question is, why are companies escalating this migration now? Wait, One major factor in the background is rising cost of doing business in America. If you are an H-1B tech worker or a corporate NRI in the US, the sudden surge in tech import tariff isn't just a macro headline. It is directly escalating silent layoff and frozen perm filing in Q3 2026. Well, the US trade regulatory architecture underwent a seismic shift as a new Section 301 duties take effect on July 24, 2026, replacing the temporary Section 122 global tariff. Covering 60 trading economies and over 99% of total import volume, these 10% to maybe 12.5% surcharges, it hit Asian hardware, semiconductor components and server infrastructure head-on. For major tech corporations, hardware costs and server deployment capital expenditure have hiked overnight. Enterprise tech margins, already by the way stretched thin by higher interest rate and massive AI infrastructure investment, are reaching a critical breaking point now. Chief financial officers across Silicon Valley, Seattle, Austin, they are scrambling to absorb these supply chain adjustments though, with core component costing jump and maybe global supply chain force into extensive China plus one workarounds in Vietnam, India, Mexico. Corporate earning guidance for Q3 and Q4 2026 is taking a direct hit now. You know, when tech giants face margin compression from non-negotiable trade duties, well, they cannot easily cut the hardware supply chain. Instead, they pull only operational level remaining, reducing the internal headcount, slashing operating expenditure, and freezing hiring budgets. And ladies and gentlemen, this brings us to the human cost of trade realignment. Big tech and enterprise software firms are opting for silent layoff now. Performance-based PIP purchase, strict 5-day return to office mandates used as attribution fillers, and multi-year perm processing holds. You know, for high-earning foreign tech professionals on H-1B, L-1 or O-1 visas, this margin, it translates directly into risk. A sudden layoff gives the H-1B holders exactly 60 days to secure a new qualifying petition, transition to B2 visa bridge, or face voluntarily self-deportation. Well, as tech hiring freezes expand alongside tariff pressure, finding a sponsoring employer within that 60-day window, that becomes significantly more difficult. But yes, the story is not only about American companies cutting the cost here. Indian companies are also pouring billions into the United States, and that could create a new opportunity for Indians in the US. If you are an H-1B tech worker, executive, or corporate NRI in the US, let me tell you, Indians, they are pouring over $20 billion into the US soil. That isn't just macro news for you. It is opening massive L1 transfer pathways and greenfield tech jobs across the country. US Ambassador Mr. Sergio Gore, he officially praised Indian enterprise leadership after confirming that Indian firms have committed over $20.5 billion in direct foreign investment in the US. That's right. Speaking at the Indo-American Chamber of Commerce, Mr. Gore highlighted that the US Embassy in India ranked #1 globally, and that too in job creating capital into the American economy. That is not just capital. Top Indian giants across pharmaceuticals, tech infrastructure, manufacturing and AI supply chain, including Sun Pharma, Natco Pharma and other companies also, including JSW Steel, they all are expanding major physical hubs across states like New Jersey, South Carolina, Texas and Mississippi. Well, for the foreign professionals and corporate NRIs, this historic $20 billion expansion, it creates a critical pivot here. As Indian corporations establish greenfield projects and expand the US-based subsidies, they trigger a surge in L1A executive and L1B specialized knowledge visa petition. Now let me simplify that. Unlike the H-1B visa, which remains subject to strict annual lottery cap, and wage-weighted selection hurdles. L1, intra-company transfer. It allows Indian multinationals to bypass the H-1B lottery altogether. High-earning managers and tech leaders in India, they can be transferred directly to the US operational facilities. Therefore, the L1A visa holders, they enjoy a path to permanent residency through the EB-1C multinational manager green card category, completely bypassing the perm labor certification backlog that is currently stalling thousands of tech workers. However, yes, with multi-billion-dollar cross-border capital expansion comes heightened regulatory scrutiny here. US-based NRIs managing dual jurisdiction corporate entities or maybe receiving cross-border equity packages must navigate strict IRS enforcement around the transfer pricing and cross-border asset disclosures. But wait, what happens if you lose the US job altogether? Well, a proposed DHS rule, it could change the answer dramatically. If you are currently working in the US on an H-1B, L1, O1 visas, the Department of Homeland Security just submitted a regulatory proposal that could completely eliminate your 60-day post-layoff grace period. Losing your job and having only a very short window to find another sponsor, that could change everything for workers with mortgages, children in school, years invested in green card backlog. On August 6th, the Department of Homeland Security submitted a proposed rule titled Eliminating the Discretionary 60-Day Grace Period to the Office of Management and Budget. While the full regulatory text, it is still undergoing administrative review before its formal public release. The objective of the proposal, it is unmistakable. Removing the 60-day safety net that has protected non-immigrant workers since 2017. For nearly a decade, if an H-1B, L1, TN or E3 worker was terminated, then USCIS granted of maybe 60 consecutive days or until their valid I-94 expiration, whichever was shorter, to remain legally in the US. Well, this window allowed highly skilled professionals to negotiate severance, interviews across market competitors, file the H-1B transfer petition, or change their visa status without accumulating unlawful presence. Well, if this proposed rule, it goes through the OMB review and clears the public comment phase intact, that 60-day cushion, well, it will disappear entirely. Severance pay does not extend your H-1B status. USCIS measures your employment termination date by the last day you actually work for the company, not the day your salary continuation or lump sum severance check stops here. Without the 60-day grace period, securing a new job offer, getting a labor condition application approved by the Department of Labor, and having a new employer file the form I-129, that becomes an extremely tight timeline. Immigration experts, they highlight the tactical move, including the H-1B visitor status bridge, cap-exempt employer, and AC-21 portability for the approved I-140 holders. It's a vital part to understand that as of today, August 19, 2026, the 60-day grace period remains legally active. That's right, the proposed rule in the federal review and must undergo a mandatory public notice and a comment period before any final rule is published. And yes, while immigration rules tighten, corporate America is facing another pressure point: the rising cost of hardware itself. If you work in a big tech, IT infrastructure, or corporate engineering, a massive financial shockwaves just hit your company's balance sheet. The US trade representatives have finalized new Section 301 tariff surcharges, adding up to a 12.5% import penalty across key hardware and technology supply chain. When a corporate hardware costs jump by double-digit overnight, chief financial officers, CFOs, they don't just absorb the hit. They cut operating expenses, freeze the headcount, and accelerate the offshore migration here. Following the extensive federal review, the US government implemented new baseline tariff tiers targeting the imports across 60 global economies. While certain jurisdictions were reciprocal labor commitment face a 10% additional duty, major tech manufacturing hubs and standard trading partners are hit with a full 12.5% surcharge. For the tech companies importing networking gears, servers, semiconductor assemblies, and consumer electronics hardware, landed import cost it has spiked overnight. Now, to understand why a trade policy on hardware impacts the software engineers, data architects, and IT leads, you have to follow the corporate income statement here. Well, in enterprise tech, operating expenses, they are primarily split between capital expenditure on infrastructure and payroll. Well, when Section 301 tariff instantly raised the landed cost of service, in fact storage arrays, by 10 to 12%, hardware margin that drops. Publicly traded tech firms operating under strict quarterly margin guidance from the Wall Street, they cannot simply allow gross margins to compress here. To offset hardware import penalties, corporate finance teams, they enforce immediate operational tightening. This manifests are restricting the corporate IT hardware refresh the cycles, cancelling non-essential cloud infrastructure expansion, and enforcing quiet hiring freezes across high-cost offshore engineering role. And yes, there is another major structural byproduct here: the rapid shift towards India-based GCCs. Now, by shifting the software development, platform management, and cloud architecture tasks to GCCs in India's Bengaluru, Hyderabad, or Pune, US tech giants can offset their US import tariff losses through offshore payroll optimization. Now, from the US, we now move to another financial hub, ladies and gentlemen, that is actively trying to attract wealthy global professionals, including Indians here. If you are a high-earning NRI in wealth management, private equity, or tech, Singapore just made a massive regulatory move designed to bring your capital and your talent to their nation. The Monetary Authority of Singapore has officially unveiled plans for tax exemption on fund management profits and expanded access to its primer 5-year multi-employer visa, the one pass basically. On August 19, 2026, the Monetary Authority of Singapore, alongside with the Ministry of Finance, announced 3 major policy initiatives aimed directly at global asset managers, family offices, and senior investment leaders. This move, it comes as competition between Asia's premier financial hubs hits an all-time high. Hong Kong recently pushed tax incentives targeting individual fund managers and performance bonuses here, putting a lot of pressure on Singapore to respond. Singapore's asset management industry is already massive, growing at an average annual rate of 7.5% over the last 5 years and managing nearly 7 trillion Singapore dollars. Now the city-state is opening the floodgates even wider to high net worth Indians. That's right, Singapore plans to grant full tax exemption on profit-related return and fund outcomes earned by fund managers. This directly targets carried interest and performance-linked compensation, the exact income stream that face heavy tax returns across Western jurisdictions like the US, the UK, or Australia. Well, these tax exemptions explicitly cover funds managed for single-family offices and commercial fund structures set up in Singapore. Now, to qualify for these tax cuts, fund structures must meet the specific local substance requirement, including maintaining physical operation and minimum local headcount within Singapore. And yes, then there is the immigration policy shift, which we cannot miss. MAS and the Ministry of Manpower are expanding the Overseas Network and Expertise Pass, commonly known as One Pass, specifically for investment professionals here. It is valid for 5 years before requiring renewal and not tied to a single employer. One pass holder can work for multiple entities simultaneously, launch their own funds, or switch roles without having to apply for a new work permit every single time. But while Singapore is trying to attract global wealth, the UK is tightening its grip on offshore income, including money held back in India. If you are a high earning NRI living in the United Kingdom with foreign currency fixed deposit back in India, HMRS's radical tax overhaul has just created a massive financial trap for you. While Indian banks advertise 6 to 7% tax-free return on foreign currency non-resident or FCNR deposit, long-term US residents are now required to pay UK tax on that global interest income. For decades, wealthy Indian professionals, tech founders, doctors who are living in the UK relied on the non-tax status. Under the specific remittance basis of taxation, as long as you kept your offshore income, such as the interest from the UCNR account, NRE deposit, or Indian stock gains outside the UK, HMRC, it could not touch it. Now, sadly, that safety net is officially gone. The UK government completely abolished the remittance basis, replacing it with the foreign income and gains, or FIG, that particular regime. Now, under the new resident-based framework, the historic concept of domicile, it has erased from the tax purposes here. Instead, the UK tax liability is determined strictly by physical residence. If you are considered a long-term UK tax resident, then HMRC taxes your worldwide income as it arises, regardless of whether you bring a single rupee or a dollar back into the British bank account. Under Section 1015 of India's Income Tax Act, interest earned on FCNR deposit, it is completely tax-free in India for the non-residents. However, under HMRC's arising basis, UK tax resident must declare all the foreign interest income on their annual self-assessment tax return, specifically using supplementary page SA106. Now here's where the trap snaps shut. Under the UK-India Double Taxation Avoidance Agreement, or DTAA, you can only claim foreign tax credit relief in the UK for tax actually paid in India. Since India charges 0% tax on FCNR interest, your foreign tax credit, zero. Well, the new FIG regime may consider some kind of relief to qualifying non-residents. But for the vast majority of the UK NRIs who have lived in London, in fact Manchester, for more than maybe 4 years, FIG relief, it is unavailable. HMRC, they have also upgraded its digital enforcement and information sharing capabilities, by the way. While the temporary repatriation facility that provides a mechanism for certain long-settled NRIs to bring the historic offshore capital into the UK at a reduced tax rate. And yes, finally, as governments tighten the financial and immigration rules, even a valid US visa is no longer something travelers can simply take for granted. And finally, we turn to Trinidad and Tobago, where a political battle over the US visa, it has now erupted at the highest level of governments. Well, Trinidad's main opposition party has accused Prime Minister Kamala Persad of taking tales about the citizens she disliked to American officials, allegedly resulting in dozens of people possibly having their US entry visas revoked by the state government. Keith Rowley, who last year retired just weeks before his People's National Moment, or PNM, lost the general elections to the Prime Minister's United National Congress, UNC. He is now demanding answers from the government, specifically from the head of the government. He wants the Prime Minister to come clean on exactly how many citizens may have had their US visas revoked because of the action taken by the local authority. He took to social media on Monday to demand answers, particularly after the US State Department published a list of offenses that could lead to automatic visa revocation. Well, these include people who have committed felony crimes, engaged in violence against the US citizens, defrauded Americans, abused to the US immigration system, or endangered national security. Well, he is asking a very direct question here. If those are the grounds for visa cancellation, then what exactly did the people targeted by the Trinidadians government do? In fact, he specifically pointed to himself and former Prime Minister, claiming that the Prime Minister and other officials had called for their visas to be cancelled. He argued that there is no record of either man committing any sort of crime against the United States. Let me quote what he asked. Which of these offences were they guilty of? He also demanded that know how many other citizens the government had allegedly reported to the US authorities with a recommendation to have their visa cancelled. According to him, the issue goes far beyond just two political figures here. He claimed that in recent times, UNC leadership and other close to the government, they had been warning and threatening the citizens about losing their US visas further. Ladies and gentlemen, the latest political row following the recent remark in Parliament by Attorney General John, who confirmed that several people linked to the opposition and big business in Trinidad, they have lost their visas through the revocation further. Well, however, let's listen to the other side now. The Prime Minister has publicly defended the Trump administration's tough approach to the US visa assurance. She has backed the idea of turning away people who verbally attack the US while still wanting to travel there. You know her message? Blunt. If you want to travel to America but publicly attack the country, there can be consequences. Well, she described it as hypocrisy for people in Trinidad to criticize the US while still wanting to benefit from the access to the country. She also suggested that some people had already seen their visas restricted after publicly speaking against the US. So, this is no longer just a question of immigration paperwork. It has become a political fight over who has the power to influence a person's access to the US. And yes, whether domestic political disputes can spill over into international visa decisions or not. Well, for Trinidad and Tobago's opposition, demand is simple. How many visas were cancelled? Who was reported to the US authorities? And on what grounds? And yes, this dispute continues. It highlights a much bigger reality for international travelers. US visa may open the door to America, but political tension, government recommendation, and changing security policies can determine whether that stays open or not. With that, here we come to an end of tonight's Skyline, ladies and gentlemen. We had 13 stories. We have several nations, you name it. US, UK, Singapore, etc. But one common purpose. Staying loyal to the process, staying loyal to your country, and staying loyal to your ambitions. That is what it takes to be successful. I'm Dhruti Yatri, and I'll see you in the next episode.